Good morning. Happy Sunday. About a week ago, I did this video on Matt Christiansen's double standard, and Matt Christiansen has had an opportunity to respond. He says, this is an incredibly desperate reach. You probably want to watch the video before you understand this response. He says that I am doing an incredibly desperate reach. He says, first of all, you're reading into a gag bit, not my sincere advocacy of how to navigate the situation. Case closed, problem solved, kids. We can all go home. It was just a joke. Oh, wait, there's more. Pro tip, if ever you're going to say, I was just joking as a defense to what you just did, you probably want to stop there and not attempt to defend the joke. But he was, in fact, reading off of let's see if I could find it somewhere in here. It's a gag bit because he's got his pen, he's got a pad. He's not quoting from anybody. He's not saying that somebody else recommended it. He just said, let's see what exactly he says. But now we're a week out with no results of an investigation that should take, this is his words, should take exactly 2 questions in 15 seconds to complete. This is his take. This is his joke. This investigation that's taken 2 weeks should take exactly 2 questions and 15 seconds to complete. It's a joke though, guys. It's a fucking joke. Second, government as an employer. Okay. Wishing death on children, Tamir Rice was only 12, is a perfectly acceptable reason to terminate an employment relationship. I don't think so. I disagree with you. You're stating it as though it is the accepted truth, but I have just done a video where I disagree with it. Because as you admit, down here at the end, you admit that they were hysterical death wishes. Hysterical. Your words, sir, that I agree with. Hysterical. She was in hysteria. She was exhibiting overwhelming or unmanaged fear or emotional excess. Does she actually want those, in your words, children, in my words, young adults, to die? I don't think so. If she wanted them to die, why did she spend a few minutes yelling at them to get out of the park, to go home, to seek shelter, to do all the things that she believes are going to protect not only them, but society as a whole from the coronavirus? So you don't have a valid answer to that because one doesn't exist. She was hysterical. We agree on it. It's not her wishing death. It is the words she spoke. And the words that she spoke were hysterical. And I think you can make a good argument that every parent has wished death on a child. Every teacher has wished death on a child. Not meaning it, but, I just want to, I'm going to go have some chocolate and a timeout, and then I'm going to come back and I'm going to take care of you. Every parent's gone through that. When you were a teenager, you went through that. You wished death on your parents. You didn't mean it, obviously, but it's natural. I just wish you'd die. I don't really want you to die, but you know what I'm saying. I just wish you'd die. Then he says, at no point have I wished for this woman to be censored. Oh my God. You want her to be fired for the words that are coming out of her mouth. You want the government, who is her employer, to fire her for the words that came out of her mouth. This is Pickering v. Board of Education, United States Supreme Court case out of 1968. This is in the main decision. This is on page 574. While criminal sanctions and damage awards have a somewhat different impact on the exercise of the right to freedom of speech from dismissal from government, it is apparent that the threat of dismissal from public employment is nonetheless a potent means of inhibiting speech. We like to call that censorship. We have already noted our disinclination to make a cross-the-board equation of dismissal from public employment for remarks critical of superiors with awarding damage in a libel suit by a public official for similar criticism. However, in a case such as the present one, in which the fact of employment is only tangentially and insubstantially involved in the subject matter of the public communication made by a teacher, we conclude that it is necessary to regard the teacher as a member of the general public he seeks to be. We'll get to these cases later, but I think you're wrong when you say that you're not calling for her to be censored, sir. You say at no point have I called for her prosecution. Congratulations. Congratulations. You just called for her to be fired. You just called for her to lose her career as a teacher. Congratulations. You are a much more moral man than I took you to be, sir. He says if a private daycare terminated an employee for wishing death on the kids, that'd be a reasonable response. So we've switched from a high school teacher on her own time, in the middle of a coronavirus pandemic, yelling at who we can only presume to be high school students who are out in violation of the stay-at-home order, getting hysterical and saying that she hopes they die from coronavirus, to private daycare. It's slippery, my friend, but I see it. I see I'm picking up what you're putting down, sir. And a private daycare would not be the government, and the First Amendment wouldn't apply, and you can do whatever you want at that point. I still wouldn't advocate for it because I am not a hypocrite, sir. He says, third, were any of the prior examples of my videos you cited about wishing death on people? No, they were not. But there's this one. It's up here. University of student charged with felony hate crime for tying a noose. Ruh-roh is going to get spicy. Andrew M. Smith. This is your student arrested, right? He was charged with disorderly conduct and for committing a hate crime, which is a felony. Whoa, what could a hate crime be for? Well, this is well, I don't know where to start. So hate crime, all right. Hate crime, you can, if you commit the disorderly conduct based on race, color, creed, religion, ancestry, etc., then it becomes a hate crime, class 3 felony for the first offense. This is the 720 Illinois codified statutes or whatever, 5/12-7.1, because their statutes are just a pain in the ass to try to maneuver through. But it's disorderly conduct. Now, we know that in order for disorderly conduct, well, my viewers hopefully know, in order for disorderly conduct to punish speech, pure speech, it has to be unprotected speech. Now, the classic unprotected speech that we have often seen is fighting words. Words that are likely to cause an imminent breach of the peace. Can't be a breach of the peace down the road. Has to be imminent. Supreme Court has to be imminent for fighting words. But there is another unprotected class of speech that a disorderly conduct can criminalize, and that would be threats. We have seen threats before. And this is the disorderly conduct statute. Because tying a noose in an elevator when you're all by yourself is not speech that is likely to provoke an imminent breach of the peace. They have the provoke a breach of the peace up here. I'm sure somewhere in their case law that one of their state Supreme Court, whatever it is, has found that this provoke a breach of the peace has to be an imminent breach of the peace, because that's what the Supreme Court requires. But down here at 3.5, transmits or causes to be transmitted in any manner a threat, so it's a threat, so it's not protected speech, of destruction of a school building or school property or and this is where it gets spicy, a threat of violence, death. Woo, woo. Do you see that word, Matt? Do you see that word? Death or bodily harm directed against persons at a school function, or school event, whether or not school is in session. What does a noose represent, Mr. Christiansen, sir? Could it be, and I'm just going out on a limb here, a noose would symbolize the lynching and subsequent hanging of black people? Death, hanging, death. But no, sir. No, sir. You did not cite something about wishing death on people. You cited something about, or you talked about the communicating a threat of death to people, which is a substantive different thing than wishing death. Saying, I hope you die, is a completely different thing from, here's the noose I'm going to hang you with. Now, whether or not he was convicted of that threat, I don't know. I hope he wasn't. But, that's just me. So I think, sir, that you need to look at your past positions a little closer, because your hypocrisy is shining through. And finally, he says, is it your position that a government can never terminate employment for discretionary reasons? No, it is my position that the government can't terminate people for exercising their First Amendment rights as long as they're not doing it while they are working for the government. So like if she walked up in front of her class and she said, you know what, I think y'all need to die, that would be different, because she would be doing it in her official capacity as a teacher, and she could be dealt with in that capacity. So as long as she's not doing it in her official capacity as a teacher, and as long as it is something of public concern, i.e. coronavirus pandemic, then she is most likely going to be protected. There are about 5 or 6 various other conditions that she would have to satisfy. So would it interfere with her responsibilities? Would it interfere with her relationship with her supervisor, or the discipline that her supervisor could mete out to her? Would it compromise the loyalty or the confidence of her supervisor or close working associates, things like that? In this case, though, and that's what these 3 cases are talking about. Garcetti versus, I'm going to say Ceballos, but it may be Ceballos. I don't know. In this case, this is the case that said that it has to, they can't be in their official duties. Then there's Connick v. Myers, which is another U.S. Supreme Court case. This one was earlier. They got to arrive at the balance. They have to look at these various factors. And then Pickering, which we just read. Connick v. Myers, it has to be a matter of public importance. Pickering is the one that we just read. Again, United States Supreme Court decision. In Pickering, a teacher wrote a letter that was critical of a board of education, was subsequently fired for writing that letter. They said it was full of lies, blah, 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 right? But from the language that I read to you, this language right here, I think there is a good case that I would be able to make that this teacher, who doesn't come out saying, I am a teacher, she comes out just as a person, as a citizen, I think she'd be protected by the First Amendment. And I think I can make a very strong argument for that. I don't think her position on the coronavirus would interfere with her responsibilities in any way. I don't know if these were her students. If they were her students, then that might be an issue. But if they were not her students, then either the school would have to take steps to make sure they didn't become her students, or then it could be an issue. Whether or not it would well, I don't think it would create any disharmony in the workplace between her and employer, or her and other employees. So I think she is protected by the First Amendment, with the caveat, I don't know if these were actually her students. So facts would have to come out about that. I didn't see anything in any of these stories that said that they were her students, but I do believe that she would be protected by the First Amendment. Now, just to help you out, the government can terminate employment for discretionary reasons. Government agencies can do that. The issue is that they can't terminate for protected things because of discretion, if that makes sense. So, like, for example, race. You can't fire someone based on the color of their skin. Race or color, I should say, race or skin color. You can't fire someone based on the color of their skin. And you can't get around that by saying, "Oh, I'm firing this person for discretionary reasons." Well, no, it's if every time you get a black person assigned to your department, you're firing them and you're only retaining non-black people, then it's going to look like you're firing based on the color of their skin, and no longer is it discretionary reasons. Same thing, jury. If you're selecting a jury, you have complete discretion on what jurors you excuse, generally speaking, but you can't do it based on race. And if you're excusing only black jurors, then the judge might get involved because the other side might object and say, "Hey, he's excusing all the black jurors or all the white jurors or all the yellow, whatever." But you get my point. So you can't use discretionary reasons as an excuse to cover up firing someone for protected things like color of the skin or First Amendment. I think I answered why, but this last sentence, this is just pure propaganda gold. Why should the taxpayer be extorted? Why should the taxpayer be extorted for the forcible support of a woman who wishes death on their children? Wow. Let me just say that her having a job as a teacher is different than forcible support of a woman. But what you are suggesting, Mr. Christiansen, if I might just slap a little more of the hypocrisy out of you, sir, is that we fire her, in which case she would go on unemployment. And the taxpayer would be extorted for the forcible support of a woman who wishes death on their children, you dumb fuck. Anyway, thanks for watching. Have a great day.